Students, our today's topic is marriage under private international law. As we all know, marriage is not a new term even in the communities, religion, countries. Since ancient time, marriage subsists as a sacrament or a contract. Whatever the form of marriage, the main thing is that two persons get united, certain rights and obligations binding on them, and if they want to separate, certain rights and duties arises. They cannot move away just by saying okay, I am going. So laws are there, and when two persons belongs to different nation, further complexity arises. Why? Because the laws of nations are not uniform throughout the world. There is major difference in legal provision regarding the formalities of marriage, validity of marriage, performance of marriage, and how it will be dissolved. And further, the other issues that are to be dealt with. For example, if there is a question of legitimacy of child, or the succession, or the will, and further, if the marriage dissolved, maintenance, alimony, right of children, inheritance, that is peculiar feature of Hindu law. So when the time comes and the dispute arises, then the private international law come into the action, because the party, one party and the other party, both belong to different nations. For example, two Hindus of India, they married in India according to the ceremonies of Hindu religion, and they shifted to USA and they lived there for 7 years. And meanwhile, the dispute arises between husband and wife. Wife came back India and she filed a suit here for the restitution of conjugal rights. The husband appeared and he said the already divorce has taken place, and he said that the USA courts have the jurisdiction to deal with the matter. The Indian courts have no jurisdiction to deal with the matter because they have the permanent residential status of the America. So how this dispute will be resolved? Whether the American courts have the jurisdiction or the Indian courts have the jurisdiction, whether the dispute is dealt with the Hindu law, Hindu Marriage Act, or Hindu Succession Act, or it is dealt with the laws of the states of America. The reason why this conflict is important, because for example, alimony and maintenance provisions are different in India and it is quite different in America. Age of marriage, even for example, if the case of void or voidable marriage, so age of marriage in India is 18 for girl, 21 for boy, but it is not so in America, Canada and other western countries. It is 16 year, somewhere it is 15 year, and in certain countries of Africa continent it is even less than that. So which marriage is valid? If two Hindus went to Pakistan and they performed the nikah, and then husband further perform another marriage, as he said that I am living in Pakistan, here 4 marriages are allowed. Is it possible? Is it valid way of doing marriage? Whether the marriage is null and void or it is okay? Or the polygamy is allowed in India? No. But in Muslims it is allowed so. But if he is Hindu, then there is a conflict, and this conflict is resolved by the private international law general principles.